Yes.
May I, Lordship? I beg to mention item number 3, Your Lordship.
Fix
Uh,
item.
Item number
Okay.
Item number 3, Your Lordship. This matter will appear by PD Nair, sir. So he could not appear today due to some personal difficulties. This
Mr. You are appearing on behalf of Mr.
PD Nair.
Okay, PD Nair. Then we'll adjourn.
Yes, this matter may be fixed on 23rd of February, Your Lordship.
Okay, consent taken. Is
Yes, I have taken.
Third would not be possible.
So
Oh,
give a
February.
date
February.
consensus of
No,
both
no,
the parties.
But 23rd February will not be possible.
Hmm.
It can be on 24, 25, 26. These are Nisi Nyokums. So
So
that
give a date consensus of both the parties.
second March.
2nd March.
2nd March.
Okay.
That will be fine.
Okay. Mention is made on behalf of Mr. P.D. Nair, Learned Counsel for the appellant, for adjournment of the matter, which is not objected by the other side.
Correct.
In view of the above, as sought for, list on 02/03/2026.
Great.
God bless you.
I beg to mention item number 7. The conducting council is out of stations.
Okay. What is the idea about?
For the condemnations of the delay.
Mention is made on behalf of Mr.
S. Sunil Mao,
Okay, so whose name is reflected here? Tapinuki.
Tapinuki.
You are Tapinuki?
Yeah.
Okay. Mr. Tapinuki, Learned Counsel for the applicant, has prayed for adjournment of the matter
Matter may be fixed on 22nd of this month.
by submitting that the conducting counsel, Mr.
Tapinuki. Yes, Mao. Sunil Mao.
Sunil Mao, is not able to appear today, being an outstation.
Matter may be
Counsel.
fixed on 2nd of this
The above.
22nd
For list on 22nd.
of this month.
22nd, 01, 2026, yes.
Much obliged.
Yeah, Lordship. Lordship, I beg to mention item number 23.
Yes, hearing.
On behalf of Learned Counsel, T. Gatso.
So the thing, legal aid counsel, PP, consent taken. Okay.
Consent taken.
Mention is made on behalf of Mr. T. Tapak, is it? Learned.
T. Gatso.
Okay, T. So-and-so, Learned Counsel for the appellant for adjournment of the matter with the consent from the other side. In view of the above, give us a date.
After 1 week.
As sought for, list after 1 week during the first week of February 2026. Okay.
Lordship.
May I please, Lordship? Lordship, I beg to mention item number 6, Lordship. I was supposed to file an additional affidavit here, but I could not, Lordship. I may be given some more time.
Okay.
Yeah,
Will reflect your name, Mr. So-and-so, Learned Counsel for the petitioner is present along with Ms. So-and-so, Learned Senior Government Advocate, I think, for the respondents number,
No.
for the state
Okay.
respondents. Okay. The Learned Government Advocate has prayed for
Okay.
further date to file the additional affidavit. In view of the above, as sought for, list on, when will you be able?
Let it be on third, Lordship.
Third,
3rd of Feb, Lordship.
on 03/02/2026.
Much obliged.
Item number 1.
My pleasure, Lordship. My lord, this is contempt petition, my lord. This is contempt petition, my lord, against the order passed by a single judge as well as my lord, this division bench also, my lord. My lord, may I kindly see this order, page 11, my lord. This is the order passed by the single judge on 23/5/2025, my lord. My lord, the operative portion, if your lordship may Can you see it's at page number 28?
See, you're praying for the execution of the order passed by the single bench.
Yes, ma'am.
Okay. And the judgment of the single bench was upheld
Yes, ma'am.
by the division bench
Yes, yes.
by dismissing the
Yes.
appeal.
Yeah.
In view of the above, this contempt petition has to be filed before a single bench.
My lord, we were the petitioners, my lord. The respondents went in the appeal, my lord. That order was upheld by the division bench. my lord.
So the order of which this thing, the order of the single bench, isn't
Yes.
it? So you place the matter before the single bench for as a contempt petition for execution of the order of the single bench.
Yes.
Okay, before the
No,
appropriate forum.
my lord, we actually, it was the registry which said that it should be listed before the division bench. my lord. We filed this contempt petition, but
So we will inform to before the appropriate bench. We'll
Yes.
give to you, okay? Mr. So learned counsel for the petitioner is present. This bench, no, instead of this bench, we find that this matter should be placed
No.
before,
my lord, wouldn't there be any problem in the future? Because the order of division bench also would amount to violation of division bench order. Then it
No.
would be,
the division bench has not passed any order, it has simply upheld the
Yes.
judgment of the single bench.
yes, yes.
So contempt has to be placed before a single bench. No order has been passed by the division bench. It's just upheld.
Yes.
Okay, so it has to be before the single bench. Okay, before a single
वो
bench.
जैसे बोलते हैं।
Accordingly, a contempt petition number 02. Okay, single bench registry to do the needful.
Yes.
Okay, yeah.
Obliged, ma'am.
Item number 2.
May I please, Your Lordship? Before I start with the matter, I must submit one thing, that the affidavits have been filed by the respondents, and I am not filing any reply against those affidavits because the affidavits are otherwise supporting the case of the PIL petitioners. So therefore, I'll just place a few facts of the matter because I seek an order from His Lordships because the upcoming festival is on 26th of February.
Hmm.
Lordship, if I may just submit that, Lord. If I may just submit, Constitution Article 29(1), what it provides, if I may just read that for a moment. Because what is the issue herein is that this particular festival, which we are now saying that has not been allowed to be enjoyed in the manner that it is traditionally been enjoyed, is basically emanating from the rights that comes from the Constitution, Article 29(1). If I may just read that, Lordship. Constitution है?
I think we'll list this matter in the next week, okay? Because the last order was that you should file your rejoinder affidavit to the counter affidavit.
But then what I have
Now
seen,
you're
Lordship-
submitting that since you are not filing any rejoinder
Yes, Your
affidavit,
Lordship.
so pleadings are complete and then we will list it for admission.
What I am
in
praying
the
for,
next
Lordship,
week.
what I am praying for. So the entire issue is a very small issue. I will just place that. What is it
Okay,
happening
what's
is,
the matter?
there is a particular, there is no, if I may just place that. So the issue basically is the Nisi tribe of Arunachal Pradesh, they have a festival that is called the Nyokum Yolo Festival.
Okay.
And that is held every year annually in February 26.
Hmm.
So February 26 is just coming down the corner.
Yes.
Now, in this particular festival, traditionally, they have a festival where there's a cultural aspect and a ritual aspect. Now, what had happened in the last year, that ritual aspect was not allowed to be performed by a section of the community of the Sagali town.
You are pressing for the interim prayer today.
Yes, Lord, sir.
That is-
Interim in a small, the interim of the nature that the deputy commissioner, an observation the deputy commissioner will ensure that the particular festival that is upcoming, that may be allowed to be done in the proper manner with the deputy commissioner's supervision and protection, Lordship. In that Sagali town.
PIL about.
That's what I'm coming to.
Oh.
The PIL is basically for conserving the rights of a section of the Nisi community who believes in the indigenous faith. They are indigenous faith believers. Now they have a particular festival called Nokum Yolo.
Okay.
It's a festival which is held every year on February the 26th of day. Now therein there are two aspects. One is that they have a ritual involved
Okay.
wherein they invoke the god and goddesses and seeks their blessing for the coming year. And there is also a cultural aspect to that, where there is dances and singing and programs are there. Now on the last occasion, on the last year, what had happened was that this is particularly coming from the town of Sagali. There's one town called Sagali in Arunachal Pradesh where this issue has happened. They were not allowed to perform the rituals. It is on record. Lordship.
On what grounds?
Grounds is basically, I do not want to enter that aspect. It is a particular section of people who are saying that now, from now onwards, the rituals part should not be done. We only want the cultural aspects to remain and let the rituals be not performed, because the rituals are something that is not in tune with their own religious faith now. These section of people. So therefore, there was a pressure that you should not perform the rituals, because the rituals are basically your traditional old rituals where you invoke your god and goddesses, and therefore that part today we do not want to be performed. So this led to a altercation, and finally what happened in the Sagali town, we are concerned with that particular area only, they were not allowed to hold the rituals. These are all on record. The government has admitted today in their affidavit that yes, unfortunately it has so happened in the last function or the last festival. So therefore, we came with this PIL before this honorable court to seek our right, because the Constitution Article 29(1) provides us the right to conserve our cultural identity. And to conserve our cultural identity, the government has to create that environment. We cannot take the law and order in our hand. We need the government to protect us so that we can conserve our cultural identity. So that is why we came before this honorable court. Today, the government has filed their affidavit and the governments have said that yes, the Nokum Yolo festival is a festival where rituals are a soul of the festival. And not allowing them to perform the rituals on the last occasion was an unfortunate event. So therefore, today what I'm praying,
There's a certain sect of the
the community,
that community, within
Yes,
that there are two sects, that means, isn't it?
there
One wanting to
One-
perform the ritual, and
I
the
will
other
not
want.
mince my words. I will just tell your lordships frankly, there are two divisions. One who belong to the indigenous faith,
Okay.
because Arunachal traditionally they believe they pray the nature, and then now there's another sect who are believers of the Christianity religion. So they have basically said that you cannot perform your rituals. That led to this altercation, and last occasion the rituals were not allowed to be held. The public, it's not the government. The public who belong to the other sect, they were in a majority there, and therefore they did not allow them to hold the rituals.
Okay.
So this ultimately had led to an infringement of our rights under Article 29(1), which says that I have a right to conserve my cultural identity. It's my culture. In Sagali town, from time immemorial, they have held this Nokum Yolo festival with rituals. The government have now said in their affidavit that yes, I will also, if I can also place the circulars, the government circulars.
Okay. So in here, you're saying that in your writ patent, it is the Christian converts who don't want to hold the ritual, isn't it? So they are the majority in
Yes,
that
in that town,
that
Lordship,
town.
Sagali town.
Okay. So supposing you hold the ritual,
Yes, Lordship.
the other, that is the Christian converts,
Yes, Lordship.
they need not attend if they don't want to.
That is
Can
their
that be-
prerogative. That is
Can
their
that be this thing?
we
So it's not compulsory for them
no
to
there
attend
is
to the ritual.
there is no
isn't it?
question of attendance.
Okay.
There
Uh-huh.
anyone
How is the
who
ritual held? How is the ritual held?
The rituals
How
are-
do they do, huh?
what happens is they have a priest house.
Okay.
This festival is held on the 26th, the basic festival, the main festival, 26th of February. Before that, from the 20th, the festival starts, wherein they have a priest house in that particular field. They have a field that is called the Sagali Nokum Yolo field or Nokum Yolo
Field.
ground.
Okay.
Nokum Yolo ground.
Ground.
So in that ground, they have a priest house, which is also sanctioned and financed by the Directorate of Indigenous Affairs. the Department of Arunachal Pradesh, they have sanctioned that house. It is called the Namlo, that is the priest house. So the priest comes and the priest then has a lot of rituals. And I am not in that position to explain to your lordship, but there is a lot of rituals which has got deep connections from time immemorial. What my learned friend says that he has, in fact, his forefathers have been doing all these rituals. The rituals which is more tuned with the praying of the nature, with nature.
Constitution says freedom of religion. Is it-
Article
what?
29(1), if I may just read that,
Yes.
29(1), protection of interest of minorities. They have become minorities in
Okay,
the
you're a
town of
minority there,
Sagali. Article 29(1), just you kindly see. It's a very interesting issue otherwise.
That's what I'm more.
So I don't want to bring it into that religious aspect and all. It's basically two
In fact,
section of
I would
people.
be interested to go and see how the ritual is still had in this modern day.
If a lordship allows, then lordship is most
Anyways.
welcome this time.
Anyways, see, sir, please read,
29 lordship. Protection of interest of minorities. Article 29(1). Any section of the citizen residing in the territory of India or any part thereof having a distinct language, script or culture, we are on the cultural part, of its own, shall have the right to conserve the same. So the right flows from the constitution. I have the right to conserve my cultural identity. Now, how do I conserve my cultural identity? I cannot take the law in my hand. I want the government to create the environment so that I can protect my cultural identity, conserve my cultural identity. Unfortunately, what happened on the last occasion, the government pulled their hands.
Okay.
Both parties took the issue to the deputy commissioner. The deputy commissioner pulled their hands. Deputy commissioner said that these are all issues, we cannot enter into that, you sort it out. You take your festival to some of your own place, your private place, private house, you do whatever you want to do.
Okay, not in the public.
Not in that ground which is particularly meant for this. So therefore, our rights were infringed. We had to come to this court in filing this PL.
So the other sect of the society.
I have made them a
represented today?
I have made them a party. Notices were sent, and lordship, there is an order that notices have been received by them. They have not come before this honorable court, and therefore we are proceeding ex parte today.
Okay.
They have choose not to come before lordship even after notices were served and received by them. So that also indicates or gives a message that they feel somewhere that what they have done last time was not correct.
Please.
There was previous orders lordship. Respondent number 7.
Service of notice upon 6 and 7. 6 and 7.
Yes, 7 lordship they were.
7. Everyone in the stadium. Await for report. Then let's see. Because passing an order without
I
the other
understand.
party being present,
there
so
is
we
an
have
order,
to be
Lordship. There is an order.
satisfied, yes. 6, then if it.
6 have filed the affidavit. 7.
6 is whom? The state?
6 is the
Six year was.
6 is the
Central Yokom Committee.
also for the entire state. They have a central Nokomyolo committee
Okay.
recognized by the government. So they are 6. Their affidavit they say I support. Yes, rituals are a soul of
Okay, so
Nokomyolo.
you are supporting.
Yes,
So now where's the notice complete upon 7? So that we can. at
it was
least-
there on one. I apologize. I do not remember the date, but I have
wait, wait.
categorically submitted and
Respondent, the same is placed on record. Affidavit in reply, affidavit on behalf of respondent.
that order was there.
Return of AD in respect has been placed back and service report is still awaited. AD card in respect of Bakalan filed on behalf of
6, I think.
respondent number 6. Wait, Representative filed on behalf of.
There's a judicial order to that effect.
So on 20/09/2025, okay, it says that AD card in respect of respondent number 7 has been received back.
Yes.
So let's look at the AD card.
So there is a
The
judicial order to that effect.
correspondence, they are not finding the judicial order. That's
No,
it.
if
No
I,
order is there.
There's no order.
there is a court order
Completion of service.
because this,
So let's see the
not in
correspondence.
the office note, Lordship, in the court orders.
Is there a court order or just? see?
Yes, Lordship, if I may
Then
just,
at least we can,
yes, it was
because basically it's between you and respondent number 7.
it is
the other
basically with the government, Lordship. The government should have protected us.
Anyways, no. Okay, AD card.
There's a signature, Lordship, and that
Yes.
was noticed by
So
this
we'll
honorable
we'll
court.
have to reflect this.
I think there is a judicial order to that effect.
There's no
I-
judicial order.
No
That's
judicial.
right.
I remember this affidavit, this AD card was seen by the court on the last occasion also, and
Okay,
there
but
was,
but
Ma'am,
there's
just
no
see,
order.
just see.
there was one
411,
order.
411,
411.
There was one order.
411, second.
So supposing this ritual is held,
Yes, Lordship.
okay, in the field,
Mhm.
in that, is it a village or a?
Just town, Sagali town,
town,
small
in the
town,
town.
small town.
Mm.
This is a
Here,
localized issue as of.
4/11/2025.
Yes, Lordship.
However, service report from a process server is still awaited. Regarding service upon respondent number 7, it says that it appears that notice has been served upon General Secretary of the Association.
Yes.
However, service report from process server is still awaited.
Thereafter, Lordship, I think.
You see, because my only concern is if we pass the order which we are praying for
Yes, Lordship.
to be allowed to hold the ritual,
Yes, Lordship.
okay, if we allow that, then the whole PIL itself is decided today. Because if you allow and then continue,
Yes.
are you getting it? Because the whole PIL is regarding you not being allowed.
Sum and substance of the entire PIL is that not been allowed,
Ah,
but then
so-
ultimately what we're
So
looking
if we
for. is-
allow this time,
Hmm.
then the whole PIL itself will be decided
Will be decided.
by today's order.
The entire issue is that it's not
Because
for,
that's-
not for a particular year. What we need from your lordships is basically an order so that there should not be a continuation of this issue. Maybe for this year we are protected. Again, next year it might so happen. So if there is a properly structured judgment finally, that this thing should not happen. Now it has happened in the town of Sagali. Tomorrow it can happen in some other towns also. So that is the bigger outlook of this PIL
Sagali.
otherwise.
In the, okay, this is the town of, I'm just trying to understand
Yes,
that.
Lordship.
It's a town of Sagali, okay? So here in the Sagali town, you have a certain sect of the society who stay there. But what about the rest of the Arunachal state?
Yes, for the rest of the Arunachal state, Nokomilo is held with the rituals. That is what the Central Nokomilo Committee, which is
Okay.
the head for the
Uh-huh.
entire state, in their affidavit
Okay,
states.
it's held in other,
Yes,
it's only
this-
for this particular.
Because here we have
okay.
become a minority.
Hmm.
In this particular town, we have become a minority. These are small towns in Arunachal. The population is not that much. So here, this is what has happened. But the
Okay.
fear is tomorrow this may ultimately spill over to other places also. So therefore, if there is a
So have you
proper,
mentioned that in your PIL, saying that the rest of the towns, okay, where this community resides,
yes,
they are holding the this ritual?
that I may not have stated that way in that sense, but the Department of Indigenous Affairs,
Hmm.
the government department,
Hmm.
in their affidavit have stated that by annexing their notification,
Okay.
wherein they have stated that Nokomilo.
Let's see
Yes,
that
Lordship. Yes,
notification.
Lordship.
Paragraph 8, Lordship.
That is very important. The government, the department, which is the concerned department for supervising and overlooking the affairs of the indigenous tribes, have stated that. If a lordship will take up the affidavit of the Department of Indigenous Affairs, respondent number 3, lordship. Affidavit filed on 23rd of December.
Affidavit by respondent number.
3, lordship.
Wait, I'll just-
Ah,
yes.
Lordship has got that? Yes. If a lordship will come to paragraph number 8. This paragraph number 8 is basically my entire case and the reply of the government.
Mhm.
Page 383.
Yes.
May I just read that paragraph? That with regard to the statement made in paragraph 12 of the PIL petition, the answering respondent begs to state that by notification dated 9/3/2024, published by Gazette Notification 160 dated 18/3, the government has issued a guideline for providing financial assistance for celebration of local indigenous festivals of Arunachal Pradesh. The festival of Nokom Yolo is listed in serial number 12 of the list of festivals declared by the government to be eligible for financial assistance. Pursuant thereto, by the sanction order dated so and so, issued by the Department of Indian Affairs, the government of Arunachal Pradesh, financial assistance of 25 lakhs was sanctioned for the construction of Nokom Namlo Priest House at the Nokom Yellow ground at Sagali, and the work was executed under the supervision of the Public Works Department. The said financial assistance was sanctioned to enable the tribals of the Nisi tribes to perform and celebrate their Nokom Yellow festivals with rituals. Lordship will mark that, with rituals, in its true and original sense, and for the purpose of Nokom, and for that purpose, the Nokom Namlo Priest House, which is mandatory requirement for performing the rituals involved in Nokom Yolo, was constructed in the Nokom Yolo ground at Sagali. It is pertinent to mention that rituals is an integral part of the Nokom Yolo, and thus no Nokom Yolo if ritual is taken out of it. The Nokom Namlo is constructed at the Nokom Yolo ground at Sagali for that very purpose, where the priest can come during the festival and perform the rituals. Then if your lordship will come to page 386. Now they say what has happened in the Sagali town, 386. That it is a fact that in Sagali, Nokom Yolo festivals with rituals is been performed in the Nokom Yolo Lapang ground at Sagali for many years. The government of Arunachal Pradesh and the Department of Indigenous Affairs identifies the same and has also sanctioned funds for construction of Nokom Namlo, i.e. the priest house on the said ground for performance of rituals by the priest in the Nokom Yolo festival. It is, however, unfortunate that information has been received by the department in the last Nokom Yolo festival held in the Nokom Yolo Lapang ground at Sagali, rituals were not allowed to be performed by one section of the people, thereby depriving the indigenous faith believers from continuation of their traditional ritualistic practice pertaining to Nokom Yolo festival. So why do I need to now state when the government themselves, the competent authorities have themselves stated so? This is my case, Lordship. And if your Lordship will see that notification for a moment, that your Lordship will find at page 392. The government notification published in the Gazette.
Okay, fine. I've seen it.
Yes.
We will.
So this is my case, Lordship.
So today you're pressing for only interim or?
I am basically pressing because, Lordship, the festival is coming.
Oh.
We are almost coming to February, and because there has to be preparations for that. Because they will have to enter the ground, start constructing all those, whatever pandals and everything is there. So at that point of time, when law and order situation turns out, there will be a difficulty. So some protection by the Deputy Commissioner to ensure that when the PIL petitioners, the indigenous faith believers proceed for holding a festival, there should not be any law and order situation. And if there is any, they should control that. Because I have a fundamental right to conserve my cultural identity, and the government has to create the environment for doing the same. This is my case. So that's the observation. And later on, Lordships can broaden the aspect of this PIL so that tomorrow there should be no issues of this nature.
PIL. But broadening, okay, that will see.
That will be on a
that
hearing
will
stage.
be,
But today, this is my concern, Lordship.
Yes. So the.
Because their festivals have otherwise started now. What they are now doing is some rituals they have to do. They're this thing. But then they are afraid that if they go again, some law and order situation will come in. Some protection, Lordship.
Yes, opposite party, anything to say? But you're supporting the case of petitioner, both of you, isn't it?
Our stand has already been read out, Lordship.
The government
You're
is supporting. It's basically
supporting.
an unfortunate situation that this has happened there.
Okay. Yes.
Deputy Commissioner is the party in this
Only
case.
the R7.
Yes. R7, I think.
R7, what will they say, Lordship? also?
R7 also, I think we will give a final chance for the appearance, and then the PIL can be disposed of
Yes,
accordingly in the
yes,
next
Lordship.
court date, isn't it? Yes.
But one,
Mr.
A.
Yes,
Sharma, Lordship.
so-and-so, learned counsel for the petitioner, Mr. A. Sharma, learned counsel for the petitioner. Also heard Ms. G. Ekte, is it? Learned additional senior government advocate for the state respondents number 1 to 5, and Mr. Fosi, learned counsel
6, Lordship.
appearing on behalf of private respondent number 6.
Yes.
The full stop. It is seen that none appeared for respondent number 7,
7.
though this court in its order dated 04/11/2025 had observed that AD card in respect of respondent number 7 has been received back. And it appears that notice has been served upon the General Secretary of the said association / respondent number 7. Full stop. However, the service report upon process server is still awaited. Full stop. All that in italics. Okay, full stop. Then new para. Code, we find that instead of this code, we find that service report from the service process server is not received till date. Full stop. Then Mr. So-and-so, learned counsel for the petitioner submits that while awaiting for the return of service report from the process server, an interim order may be passed so that the petitioners may be allowed to
Initiate their initial preparation.
initiate their preparation for holding the
For holding
rituals.
the
Is it?
that Nokomyolo festival
Okay.
with rituals.
Holding the Nokomolo festival with rituals
With rituals.
in the designated.
In the
what?
Sagali
Okay,
Nokomyolo ground.
okay. in the
Within
Sagali
bracket, they say Lapang,
Okay, that Sagali Nokomuli ground.
Ground within bracket Lapang, they say.
Okay, within bracket, whatever. Since the said festival is to be held on
26th of February.
February 26, and there is urgency in the matter since the preparations have to start beforehand.
Starting from 24.
From
26th, isn't it?
26 is the final day. They say it starts from 24th.
Okay, 24th, so and so. Okay.
Someone is saying 23, someone is saying 24.
3 days.
But then basically it's in that period
Okay,
they hold it.
24th,
22.
make it 24th, so.
24th.
Okay. The Learned Council further submits that the PIL is filed since the action taken by the private respondents number 7, not allowing the said rituals, the same name of the ritual, okay?
Nokomyolo with rituals.
Yes, with rituals, is a violation of Article
Article 29(1),
29(1) of the Constitution of India. Full stop.
which
The Learned Council further submits that the respondents, state respondents and private respondent number 6 in their affidavits filed have also supported the case of the petitioner, and therefore an interim order may be passed in the interest of justice.
Yes, Lordship.
Okay, full stop. Then Ms. So-and-so, learned government, senior government advocate, and Mr. So-and-so, learned counsel for private respondent number 6, both submit that they have no objection to the interim prayer made by the learned counsel for the petitioner. Then we have considered the submissions made by the learned counsels and find that since urgency in the matter has been expressed by the learned counsel for the petitioner and no objection has been raised by the learned counsels for government advocate so-and-so and the private respondent so-and-so, we find it appropriate that the petitioners be allowed to start their preparation so-and-so for that festival. Okay, and
everything is in the name only.
yes, and
Nokomyolo with
yes,
rituals.
and
With
the
rituals.
a ritual as said to have been practiced since long, is it? Since
Time
time
immemorial.
immemorial.
From when this Nisi tribe had originated
Time
from them.
immemorial may be allowed to be performed on, during this year, okay, before, and thereafter. We also find that, the said PIL may also be taken up for final disposal in the next date to be listed after,
After this festival also.
okay, after the said festival, okay, during the month of maybe,
March, Lordship,
during the month of March.
so that the
By
report can
giving
also.
a final chance to the respondents number 7 to make their appearance. Full stop. The state respondents will ensure that the petitioners are allowed to perform their
Rituals
rituals, so and so and so.
in the
okay?
Nokomyolo festival.
Whatever.
At
And
the
maintain,
Nokomyolo ground.
and maintain,
You have to help her.
no, peaceably, okay, do it peaceably, without any outward interference.
Yes, your Lordship.
Then this the matter again on, give a date.
March first week, Lordship. Or on 9th, Lordship, 9th, it's a Monday, 9th of March.
That's the matter on, okay, 09/03/2026, yes.
So only one
Mhm.
prayer I have.
Mm.
If something happens in the meantime, I may be allowed to mention this matter.
No, that is.
Because it may-
So
if
it's open,
something
yeah.
happens, That's. okay.
It is however open to the petitioners to make a mention if something happens. So just that, because we don't know as to what will happen.
No, don't be so apprehensive, the.
I am not there.
The state will make sure that nothing happens peaceably without adverse interference.
Lordship,
okay?
yes.
Just leave it at that, yes.
Lordship will only
Comments.
clarify that Nokomyolo with rituals, because that is where the catch
Yes,
is.
please mention.
Nokomyolo with rituals, that is the catch.
Festival,
Because
huh? Yes.
they will hold Nokomyolo, but the issue
Okay,
is the
yes,
rituals or
sure.
non-rituals. That is the issue. Oblige, Your Lordship. I'm grateful, Lordship.
Item number 4.
Yes.
Please, Lord. My lord, this is regarding, my lord, cancellation of the selection process. My lord, before I proceed, my lord, may I lordship take your lordship to the order dated 24/11/2025, my lord.
Page,
My lord, it's the order of this honorable court, my lord.
oh,
It might
of
be
this court,
Yes,
okay.
ma'am.
Yes,
Yes.
what does it say? Yes.
24/11/2025, my lord.
Mhm.
My lord, while issuing notice to the respondents, my lord, in paragraph 7, my lord, my interim prayer has been kept open for consideration on returnable debt, my lord.
Mm.
My lord, till today, my lord, the respondent has not filed their response, my lord, affidavit. Therefore, my lord, today, my lord, I'm praying for my consideration of my interim prayer.
Yes, have you received any instructions?
So far, instruction from respondent number 4 is concerned that we have received. This we are filing within a week. And for respondent number 1 to 3 losses.
So what is this thing about, this is
Some advertisement.
filling up of post?
Yes, this is regarding, my lord, appointment to the post of finance and account officer. My
Okay.
lord, earlier,
Oh, yes, cancellation.
yes, my lord, cancellation of debt.
Of the, so that a fresh, this thing, advertisement be issued.
Yes, my lord, I have
And
apprehension that,
you had appeared for the preliminary examination.
yes,
and
my lord.
Your name was there. So what
My-
is the interim period?
But interim prayer is, my lord, why I'm, my lord, appearing, my lord. My lord, they have given a tentative date for the examination, my lord, already published, my lord. And my lord, within this week or 2 months, they will issue a press advertisement, my lord.
They will what?
They will issue a press advertisement, my lord, for filling up of this post, my lord. My lord, what is I'm concerning is that, my lord. Ma'am, so may I take this? Huh? See,
But see, why did they cancel the first advertisement?
yes, my lord. My lord, to that aspect, my lord, I have to take yourself to my writ petition, my lord. My lord, what happened, my lord?
Lordship, so far, lordship, merit of the cancellation and all losses. For that, I think instruction affidavit on behalf from the department would be required, lordship. But so for the interim prayer is concerned, Lordship, because there's no urgency. After it has been cancelled, if advertisement is there, Lordship, even advertisement will, the examination will not be conducted within a week, Lordship. The time frame will be given. So
No,
No, interim praise that till the next date of listing, we will say that no fresh advertisement.
yes, my
should
lord,
be
that is
issued.
fine to pray, my lord.
Isn't
My lord,
it?
since my lord, they have already,
Because we have to see the legality of the first cancellation order, cancelling the first advertisement.
yes, ma'am.
So in between, while the matter is being sub judice, there's a petition. I think it's appropriate that this thing, what advertisement should not be issued till the next date of listing. Then the next date of listing, we'll see
Yes, my lord. In the meantime, they will.
what
file
is
their
the
response.
your disadvantage if this thing is not. A fresh advertisement is not issued immediately. Something you come up with that, then you can always pray for the vacation of this thing, the interim order. If there's a great disadvantage, balance of convenience,
Lordship.
okay, it's not in
Then
the
Lordship, may
interest.
Lordship, advertisements will not be Lordship given without leave of this court, Lordship.
So, okay, so
That
I
can-
think we'll
that
allow
can
the
be fine.
interim. Prayer.
Yes, ma'am.
Yes. Only thing is, in the case, the reason for cancellation is because of this thing, age, I think, relaxation. Is it?
Yes, my lord. My lord, they have relaxed the age, my lord. But what happened, my lord? In the year
No,
2020,
so do you relax the age?
they have relaxed the age.
They have relaxed the
Thereafter,
age.
my lord.
But by relaxing the age,
Yes, my lord.
there will be some potential candidates who can also still, with the relaxation of the age, appear for the exam.
My lord.
So if we don't, so after the age is relaxed,
My lord.
if the first advertisement is not cancelled, there will still be fresh litigations by those persons who still feel that they are entitled
My
to appear for the exam. So that aspect will have to be considered.
My
But anyway, we'll leave it for this
My
one
lord.
time.
My lord.
Because then that could invite fresh litigations again.
My lord, because well, at that
If
time,
it's cancelled
my lord,
and
at
then
that
age
point,
relaxation, so persons who are, because of the one-time relaxation, there could be persons who are now eligible to appear for the examination.
my lord, if
That
yes, ma'am.
aspect we'll have to
Yeah.
see, we
Yes.
won't go into that
Yes,
for
ma'am.
the time.
Yes, ma'am.
Okay. Anyway, heard Mr.
H. Lampu.
H. Labud, learned counsel for the petitioner. Full stop, also heard Mr. So-and-so, learned standing counsel. Is it? For which department?
Yeah.
Okay, for
Last one,
respondents
120.
number 3. And Mr. S. Tapan, is it? Learned counsel for respondents number 1, 2,
And
and
three.
4.
4.
1, 2, and 4.
Good stuff. The learned counsels for the respondents have prayed for further date to file their counter affidavits. Good stuff. Then, Mr. So-and-so, learned counsel for the petitioner, submits that in view of this court's order dated 24/11/2025, the prayer for interim relief may be considered. Good stuff. The learned counsel for the petitioner submits that the instant writ petition is assailing the order dated
Order dated, my lord, my lord is 16/10/2025. Notification dated 16/10/2025.
Okay, no, just the order, okay, application so and so.
My lord, impugn order is page 58, my lord. Is 16/10/2025.
Okay, 1610, assailing the order dated 16/10/2025, wherein the selection process initiated by the finance and accounts accounts officer / treasury officer has been cancelled. Full stop. The learned counsel for the petitioner submits that on the issuance of the said notification, the petitioners have the apprehension that a fresh advertisement for the said post would be issued in a short, in the near future, wherein the interest of the petitioners would be adversely affected, since the writ petition is for the state respondents to take necessary steps in terms of the first advertisement dated,
Dated, my lord, 21st.
the first one,
First one is.
2503, is it?
Yes, my 2503 to 2020.
2021. Mhm. Full stop, huh? Then, the new para, Mr. So-and-so, learned counsel for respondents number 1, 2, and 4 submits that he has yet to receive proper instructions regarding the state matter. Full stop. And then, new para, we have considered the submissions made by the learned counsels for both the parties, and we find that since the said writ petition is for upholding the previous advertisement published by the respondents dated 25/03/2021, and the steps taken thereafter, the balance of convenience would be in favor of the petitioner, and accordingly, a petitioner at this stage, okay, and accordingly find it appropriate to pass a direction that the respondents should not publish a fresh advertisement till until and permission is obtained from this court.
Right.
Okay. Accordingly, interim order grade 4 stands allowed. List the matter after 3 weeks. Give a time frame, a date, or this thing during the first week of,
Maximum.
or you want a date?
Maybe on 24.
Okay, on 24/02/2026. Anything else you want to add? After the order, okay.
And also may clarify that in respect of two posts
You
to
just
this
said
question.
Okay, okay, advertise, yes,
Yes,
yes, in respect of the post of finance and accounts officer,
Two posts.
slash
two posts.
treasury officer, comma, group A,
Group A.
within brackets, gazetted, close bracket, under the Department of Finance, comma, Arunachal Pradesh.
Yeah.
Okay. Advertisement in respect of the post.
My lord,
Okay, yes.
obliged, deeply obliged.
Item number 5.
Yes.
Lordship, the appellant here has filed a writ petition on dated 11/11/2025. And the single judge have dismissed the writ petition on the motion itself. The writ petition was filed challenging the enrollment of non-APST, the non-indigenous voter of Vijayanagar Circle. The petitioner has challenged and also made representations before the ERO for the enrollment of non-APST in the Vijayanagar 1408 Jilla Parishad constituency. And the matter came up to the when the matter was
not heard and it came up to the Honorable High Court. The single bench has dismissed the writ petition and describing that the non-indigenous to be the tribe of, to be declared as the indigenous ordinary resident of Arunachal Pradesh. Your Honor, there was a notification published on 2nd June 2019.
Hmm.
Your Honor, may please go to the notification.
Maybe we'll listen to attend the next week. This is
Page number 129 to
Concerning,
132.
electoral roll,
Electoral.
isn't it?
Oh.
Their names being, you are protesting regarding their names being included in the
Your
electoral roll.
Lordship.
Now,
Lordship, there is a provision in the notification. It is given that the one should be mandatory to be enrolled in the voter list of the Panchayati Raj. He or she should be a scheduled tribe member and an ordinary resident of Arunachal Pradesh. But in my case, Your Lordship, the entire population of the Vijayanagar circle, they are the settlers. They are settled there in connection with the lease agreement for the 30 years, which has already expired on 2020 itself. And there being the non-indigenous, that doesn't have the rights to cast and participate in the Panchayati rights, which is purely, the Panchayati rights, it's purely for the protection of the scheduled people and indigenous of Arunachal Pradesh.
now we have to see. I think since this is a pretty sensitive matter, and we'll have to read the judgment of the learned single judge to see whether there are sufficient grounds to admit the appeal.
Lordship, Lordship, please go to para 11 of the judgment.
Yes, the thing.
Yes. Page number 39 to 138.
Just at the motion stage without issuance of any notice.
Without issuance of any notice.
Because the learned single judge found that you do not have a case.
Lordship, the authority to describe a person to be ordinary residents, it is empowered only to the ERO. The honorable judge can make a direction, but he cannot declare him to be ordinary resident.
So I think we will issue notice because it needs proper hearing.
Lordship,
matter,
Lordship.
Isn't it? Whether,
Otherwise also, the basic reason for why the writ petitioner was dismissed in the motion stage. The petitioner is claiming that certain people, persons who have been enrolled, they should be deleted, but they were not made party in this writ petition.
okay, they were not paid
Non-joinder of,
Non-joinder.
yes, non-joinder of necessary parties. Now at this stage also, if we issue notice, but they are
They are not,
Yes,
still not
still-
party.
in that event, this
because some people's rights have been affected.
Yes.
So you have to
the
be made.
proper course will be, you can agitate the same this matter before the learned single judge by impleading those,
Impleading.
correcting the defects, making the necessary parties.
Lordship,
for review.
Then-
Lordship, the necessary of making them necessary party, it's not mandatory here.
No,
The
they-
ERO
because
himself,
there
the
is a-
ERO himself, the ERO, electoral registered officer, he himself has violated all the provision of the notification issued by the state government itself. While the state government have issued a notification, he should adhere the notification. There is a provision given, it's very clearly written, Your Lordship. There is nothing to be confused. If suppose the
No,
people
no,
were,
no, but-
Lordship,
but-
Lordship, if the
but
people,
rights of some people.
if the voters, Your Lordship, if the voters, they were the local indigenous or the ordinary resident of Arunachal Pradesh, we have no objection.
Okay, but.
And
that-
their
but
rights have
that
not
is
been
your claim.
infringed in there.
But that is your claim that they are not indigenous.
Lordship.
Okay. Well, they can say that we are. and our names should not be
Deleted.
removed.
Lordship,
So
our
then
state,
first-
the state of Arunachal Pradesh is a scheduled state and it is
That's-
protected through
so-
Bengal Eastern Frontier
That
Regulations.
is your claim, that is your.
Your
claim.
Lordship.
But whatever you said did not be the gospel truth. We have to hear the other side also. You see, according to you, you feel you have a very strong case. Okay, you feel you have a very strong case. But the other party, they also can counter your claim, isn't it?
Lordship.
So in that case, unless they are also made a party and have the right to be heard, we cannot simply decide after hearing you.
My lord, in fact, this case,
Huh.
there is a checkered history because these writ petitioners, they belong from Yobin tribe, which is from Vijayanagar area, that is in the eastern part of Arunachal Pradesh. Now, in that Vijayanagar area, the Assam Rifles, the retired Gorkhas, they have been settled there. Now, this Vijayanagar area was first discovered by the Gorkhas, Assam Rifles, Assam Rifle personals. And they have discovered this Yobin tribe
Okay.
also. That this tribe also, this was, they were discovered for the first time in 1961, 62. And then when the boundary between Burma and India was there, constructed, then these people also helped and they choose to remain within the Indian border. Now this Assam Rifle personnel, they settled there. Though they were given lease for settlement for 30 years initially, but they have settled there. Now they also, their population also have grown. Now they are claiming indigenous there. The Assam Rifle also, they are claiming that they are the first settlers there.
Okay,
Now,
so
this is something situation, fixed situation. But in the Panchayat Raj Act also, and there is nothing mentioned that it should be scheduled tribe. And basically, those already been enrolled. Initially, what under the rules requires that it's the persons to be enrolled should be ordinary residents. Indigenous word was not there. Local indigenous word was not there.
Anyways, unless.
And there is a process also to challenge any inclusion in the electoral roll. There is a process in the conduct of election rules, preparation of electoral rules itself, that the time for claims and objections are to be met. It cannot be done by way of a writ petition.
Lordship, we have
So
already.
the maintainability,
Person from the state should be, because the background, all the political issues involved. So we will simply say, we will be given the next week.
my lord, Miss Slim,
Because he knows the little politics and the background, isn't it? I think it's better.
my lord may simply fix a date that the
The
maintainability of the writ.
Yes, maintainability, and you get the proper instructions. But
Lordship,
you have to
Lordship,
study on.
Lordship, in that case, if I am supposed to make all the mandatory, the affected party, there are more than 3,000 to 4,000 voters. How can I make that? It's not, it's very much understandable that simply the ERO is.
Because whatever that, your objection also, so we will say, we will list it in the next week.
Yes.
Okay, and wherein the maintainability of the instant writ petition will be considered.
Lordship,
And
in
we will
contrary
allow
to
you
the,
to get
in,
Instructions. in that
Lordship, in
matter.
contrary to the submission of Learned AG, I would like to show you to the notification. Please go to the notification once.
We will see the maintainability in the next date, okay, because it's their notification, so let him get instructions on that. Because you are harping on the notification is issued by the respondents, so let him get instructions. I think he has got your point,
Yes.
okay? So after instructions, we'll look into the maintainability of the writ appeal, okay, whether it can be admitted. And then we will, the reasoning passed by the learned single judge for dismissing it outright without issuing notice has also to be considered. It needs a little bit more in-depth hearing.
Yes.
Lordship, without hearing this, without admitting my present case, it is going to be a precedent that has that will affect the entire scheduled rights of Arunachal Pradesh.
So it's
Not only in the context of Arunachal Pradesh, but entire India.
slightly
There's a long
sensitive
precedent.
matter which needs a proper hearing. So we will fix for another date regarding the maintainability and whether it deserves to be admitted or not in the next listing date. Okay. Come, to let him get instructions also. First time it's coming up, isn't it? Heard Mr. So-and-so, learned counsel for the appellant who has filed the instant writ appeal, assailing the judgment and order of a single bench of this court in WPC 519/2025, dated 11/11/2025, wherein the writ petition of the wherein the writ petition, okay, filed by the petitioners was dismissed at the motion stage without issuance of notice on the respondents. It's not. New para, the learned counsel for the appellant submit that the learned single judge had erred in dismissing the writ petition at the motion stage.
206.
Since the petitioner, since the claims made by the petitioner in the writ petition are as per the what notification?
Notification dated
Notification
2 June 2019.
02/06/2019, passed by the state respondents themselves. He further submitted that the learned single judge had also erred in observing that the principles of non-joinder of necessary parties was hit in the said writ petition. Full stop, then the learned additional AG, Mr. So-and-so, submits that he may be allowed to get instructions in the matter, and thereafter the matter may be considered again on the maintainability of the instant writ appeal. Good stuff. Okay, Mr. So-and-so and Mr. So-and-so, okay, learned counsel for respondent number 2 and 6. Prays that they may be given time to get instructions regarding the maintainability of the instant writ appeal. Good stuff. Then we have considered the submissions made by the learned counsels and find it appropriate to list the matter again. Yes, when on, give a date when you can come prepared.
Any date?
No, it's up to you.
After instructions on. I think it's better when we fix dates, then you can come fully prepared.
Fix that.
Yes.
Yes. That will be on 3rd of February.
On 03/02/2026. Yes.
Okay.
Obliged.
Item number 8.
My lord, this IA
Hmm.
is for condonation of delay.
in
How many days?
17 days, my lord.
17 days.
17 days.
I think it can be condoned, 17 days, very less number. Council.
My lord, I have no objection, but there are
What
other
about this,
respondents.
Private, state will not object 17 days. What about who are the other parties?
Union of
Deputy
India.
Commissioner, Union of India?
Appearing on behalf of MCATO,
Hmm.
it for instruction, no objection.
No,
Condemnation.
no objection.
No objection.
Okay, then we'll allow.
Yes.
Heard Mr. So-and-so, learned counsel for the applicant / petitioner who has filed the instant application under section 5 of the Limitation Act, 1963 for condonation of delay of 17 days in preferring an appeal against the judgment and order dated 19/11/2025 passed in WPC 392/2023. Issue notice to the respondents, Mr. So-and-so, learned additional AG accepts notice on behalf of respondents number.
My lord,
Who are they?
My lord,
of
State
one,
respondents?
1, 2, 3,
Okay.
1, 2, and 3.
1, 2, and 3, comma. Then, Mr. So-and-so accepts,
4, 5, my lord, R second.
Mr. Arca said,
4, my lord.
4.
accepts notice on behalf of respondent number 4 and Mr. So-and-so appearing on behalf of
MCATO.
M. Kato, learned deputy so-and-so accepts notice on behalf of respondent number 5. Full stop. No need to issue formal notice. Full stop. The learned counsel for the petitioner submits that the delay of 17 days in filing the appeal against the state judgment and order dated 05/01/2026 passed by the learned single judge was not due to any laches or negligence on the part of the applicants / appellants, but was due to the time taken for obtaining the certified true copy of the impugned judgment and order and for time taken for preparation of the appeal appeal
And
petition
getting the signatures.
and getting the signature of the
Appellants.
parties. Full stop. The learned counsels for the respondents submit that they have no objection to the condonation of the delay of 17 days. Full stop. In view of the above submissions, new para, okay, in view of the above submissions, we find it appropriate to condone the delay of 17 days in filing the appeal against the, again, copy paste, okay, so and so, being satisfied with the explanation given by the learned counsel for the applicant / appellant. Somewhere I've mentioned petitioner, make it appellant. Okay, good stuff. Accordingly, new para, IA number 15 within brackets AP 2026 stands allowed and disposed of.
my lord, the next item is similar nature.
No, no, in the appeal.
Yes, same judgment.
Hmm.
Appeal is made against same judgment.
So what is the appeal?
Delay is only 19 days. Earlier,
No.
17 days.
After we finish the IA,
Hmm.
we have to pass an order in the main writ
All
appeal,
right, all right.
isn't it? So in the main writ appeal, you're unhappy with the judgment of the learned single judge. Why?
My lord, there is a judgment of Supreme Court, my lord.
Hmm.
Page number 285. Page number 285, my lord.
Hmm.
And I am agreed by the observation
Hmm.
made by the learned single judge that the matter is not pending before the authority. But the Supreme Court has said in para 28, my lord,
Hmm.
para 28 is at page number 295.
Hmm.
It says, in respect of concluded acquisition where compensation has been finally determined, accepted and disbursed, no reopening shall be made permissible. The impugned judgment of the High Court is therefore set aside to that extent. However, in all matters which remain pending either before the competent authority, up to this much learned single judges use this sentence, but thereafter or before a court tribunal, the compensation shall be computed to include solatium and interest as above. These two words has been ignored. In the impugned judgment, relevant para is, just a second.
Okay, anyway, so we should notice.
Yes, Your Honor.
So the learned single judge had relied on the judgment of the apex court.
Yes. Your Honor.
Okay. But you say it's not applicable in your instance.
In my,
Case,
yes,
not fully applicable.
learned single judge erroneously held that my case was not pending before any authority as per para 25. But
Okay.
para 25, para 28. Para 28 says the pending matters before the competent authority or court / tribunal. And these two words have not been used.
Hmm.
Otherwise, I was entitled to get solution with interest, my lord.
Okay.
Either before the.
Anyways, heard, Mr. Okay, before that, on the disposal of IA 15, 2026, condoning allowing the, instead of condoning, allowing the condonation application, heard Mr. So-and-so, learned counsel for the appellant. Full stop. The learned counsel for the appellant submits that there are sufficient grounds for setting aside the judgment of the learned single bench in so-and-so, dated so-and-so, by submitting that the learned single judge had erred in coming to a conclusion that there was no pending matter
Before any authority.
before any other authority in the case of the petitioners. We will admit the appeal. Good stuff. Issue notice, new para, issue notice to the respondents. Then all the councils are present, okay, Mr. So-and-so, accept notice on behalf of the so-and-so, okay. Then requisite copies of the writ petition to be duly furnished upon the learned councils for the respondents. List the matter after 3 weeks during the second week of March, okay, 20.
All right.
Okay, for the learned councils to file their counter affidavits, if so advised. Yes.
All right.
Item number 9.
Item number 9 is similar nature. Only the delay is 19 days, earlier 17 days.
Okay, so similar orders. are
Similar
discussed.
order, similar
But what is the writ appeal about?
Same thing,
Same.
same.
Okay, maybe the date-
Analogous matter.
Analogous matter.
Okay.
Against same judgment.
Okay, so the date, okay, the date
the
and
date.
the WPC will be different.
Mhm.
Yeah. Otherwise, same order, everything.
Only dates are differ. Item number 9, 10, 11, up to 17, 19 days. Delay is 19 days only.
And
Wait,
18,
Item number 9 is 19
9
days.
to 17, 19 days delay.
9 to 17, 19 days.
Hmm.
So 7 and 8, 17 days.
No, only 8 is 17 days.
Okay, 17 days.
Then item number 18 is 27
27.
and 19 is also 27
Oh,
and item number 20 is 16
16 days.
and 21 is 19
Hmm.
and 22 is 16.
Okay, so you'll have to look at the number of delay, then the judgment and the date. Okay,
And the WPC number.
WPC number, only that difference.
Same.
Okay, same judge.
Same judgment, only the date of filing.
Yes.
Filing.
Yes. Difference in
Yes.
only date of filing.
So all these then in the first one.
Disposed by a common
No,
judgment.
yes, all the matters may be list together, my lord.
Okay, so we can say that, so it can be, okay, in the end, okay, in IA, in item number 8, we can mention that all these matters are analogous matters and to be listed together in the next data fixing. A single listing, then only in item number 7, we mentioned that. No, item number 8, only in item number 8, it should be listed together in the next date. Okay, yes.
Obliged.
Obliged, ma'am.
Item number 24.
You'll have to write the judgment. Okay. Okay. This is under which section? Conviction is under which section?
Conviction is 370.
Okay, 370. Wait.
76. No. I file additional affidavit in this matter. This kindly see page number and paper books also there, but I'm going by this.
Wait, if I have to file the additional affidavit,
Additional affidavit I have filed.
for what reason?
On the last occasion, it was almost heard, but matter yet to be heard.
It was heard at length, is it?
At length. Kindly see the issue is, kindly see my appeal. Appeal is one of the ground for appeal. Kindly page number 13 is paragraph 18.
Wait, page number 13, paragraph 18.
The ground of appeal is, for the ground for filing is an appeal as follows. For the special judge of Kolsha, Tirap district has not given sufficient opportunity to the accused to adduce evidence and defend himself in terms of the application filed by the accused under section 315 of the CRPC while submitting list of witnesses. Can you see, as per the 315 clause to CRPC, the accused has the indefeasible right to be a witnesses to defend his case. So, what happened? This case was not properly defended by the defending advocate before the trial court. So, as for this, again, kindly see.
So we have to see the order sheet of the.
Yes, in continuation of this, kindly see that is my additional affidavit.
Okay.
Yes, I have filed one additional affidavit here. As per the,
Wait,
as per the, yes, additional affidavit, this bone of contention is, can you see? Page number 97, annexure 1 series.
Page?
Page number 97.
97.
Yes. This is the issue.
Hmm.
As per this order, landed special PP MS Halang and the landed PDC Mr. L. Puksa are present. Accused Sri Pange Pansa present and directed to appear on the next date without fail. DW Sri Kamge Pansa, who is present today, has been examined. As agreed upon, this is the language, as agreed upon, the landed council has agreed.
By both
I am-
the
I am
learned
close, yes.
councils.
Yes, both
You
landed
have
council.
agreed.
I am closing the defense evidence. List this case on 24/7/2023 for final argument.
Hmm.
This is the issue. So,
So you
I-
agreed? So you can
this,
say that you did not give
Kindly
a
see.
defense.
page number 98. Annexure.
98,
Yes,
Ah.
this is a
okay.
El Puksha. I have made an inquiry whether you have defended the case, whether you have refused to examine, whereas application was already filed. There was only the accused person and one more this defense witness was there. But the accused person was not allowed to be examined himself as a witness by El Puksha, the defending counsel, without his consent. Then I have made an inquiry whether you have consented to drop the accused himself as a witness to defend his case. Whereas he said, I was not present in the court on that day. He didn't appear. So in that connection, he has filed affidavit saying that I was not present. I do not know the case. I was just on that day,
I was a junior advocate.
yes, junior of
Who's this?
Wangtan Wangshu. And
Who's
Wangtan
this
Wangshu
person?
was also not present on that day. I'm informed that. Even then case proceed, how it has proceed on record. And on the next that peaks 24/7/2023, this on the next that peaks for final argument, the Wangtan Wangshu appear in the final argument. And the matter matter argument concluded and the accused was convicted. This is the case. So as for the argument, this statement of the El Puksha, the representing counsel on that day, on the basis of which evidence has been closed, he said, I was not present in the court. I do not know. This is the issue. So in that situation, the trial court has concluded that on the basis of evidence on record, without any
But
defense,
how can
without any defense
how
witness.
can the defense witness be examined without the counsel? Defense counsel
That is why this matter require this thorough examination.
and this court, the court clearly says, Mr. PC, no, the defense counsel at Puksa is present.
10,
So
7,
whether
page number
the
97.
the order of this court or
Yes.
this affidavit is going to have weight, that
Yes,
we'll see
yes, I
later.
have filed
Okay, that's your first point. Next.
Yes. That is the issue. Although this El Puksha was not present, even then court closed the case saying that
But the court
One of
says he
the-
was
one of the-
present. So who
already
do we
this-
believe? We leave that for the time being.
Yeah.
Next.
yes. Next is kindly see
Next
main
point.
main petition, main appeal.
Huh.
This page number 53. Page number 53 is my application.
Hmm.
Application is under 315 of CRPC saying that one is Pange Pansa is the accused person himself who is 26 years and Kamge Pansa is the second witnesses as a defense witnesses. In which on that day 10 July Pange Pansa was examined but Kamge Pansa was examined and Pange Pansa was standing as an accused in the dock. But on that day,
The,
Mm.
now the LPUXA, the representing, the so-called representing council is saying, I do not know, I was not present on that day. Even then, the honorable court has, as per the, in terms of this, 10 July order 2023, court has closed the evidence and fixed the matter for only just one day, fixed the matter for final argument. So in the
No, but
fin-
on the day of the final argument also, the council could have easily asked the court.
Mm.
Yes,
Kindly see.
that he's yet to.
Given very bad advice to the junior council, my lord. He will get into
Kindly-
trouble for this.
On the final argument day,
Mm.
kindly see.
What happened?
On the final argument day, this this is the final argument kind of order. Page number 55, 56. He was representing council was Wangtan Wangshu. He is the senior counsel.
Mm.
Name is not reflected, but the even then he appeared. He is the defending counsel. 13 years back and Pangapansa. This is the situation. If I am to say this is the indivisible section 315 application is generally
Okay,
a,
anyway, so that is your point.
yes, that is
Then come to
that
the
is
next point.
technically lordship, if the accused is given a proper opportunity, if fair trial was done, he could have been
Wait,
the
on the
conclusion-
date,
conclusion might have
fixed,
been
on the
otherwise.
date fixed for this thing, arguments, when was it fixed by the learned trial court?
trial court was on 24th July 2023.
Mhm. So, on that day,
On the
what
same,
happened?
in the same month.
In the same month, what
same month.
happened on that day?
On that day, the
Where's the
matter
order
was,
sheet?
the matter was again not, the hearing was not concluded.
Oh,
And the hearing was concluded on, the final order was passed on this, can you see? That date of framing, date of judgment, commencement. It was reserved on 28.
so,
Can you see,
as
20
observed,
24 was the date fixed for final argument.
so,
And
so on the dates fixed for
28
argument,
on, yes,
couldn't you mention
yes.
that defense witnesses, examination of defense witnesses is not complete and another date may be fixed?
Exactly.
No.
You didn't
this,
mention?
The senior counsel is not aware of that. That is why I am saying this.
So-
Case
so-
of-
so-
Record.
How can that be? It's there on record
Can you see?
that.
Anyways, so that is one of your points.
Yes.
Okay, now let's come to the merits of the case.
Merit of the case is kindly see. Merit of the case is kindly see the complaint. Complaint parts. As per the complaint, page
Eight.
number 19.
19, isn't it?
Not go by the paper book. This is my appeal.
So we will
Yes.
look at the paper book. Let's look at the paper
Yes,
book,
we can
isn't it?
Go by the paper book.
We'll go by the paper book.
Yes. As per this page number 1 of the paper book.
Mhm.
This is the FIR. FIR is the complainant is the mother of the victim.
Wait, we're not ready yet. Let my sister have the paper book. Don't have copy. There should be 2 copies of the paper book, please see. Then we cannot keep sharing. Registry, prepare sufficient copies of the paper book and then we'll list another date, short date. Just check if paper book is somewhere missing.
Very misplaced.
Can this matter be fixed on 27th?
27th of this month,
Yes.
on Tuesday. In the meantime, okay,
Yes.
heard Mr. So-and-so, learned counsel for the FNA, also heard Mr. So-and-so, learned
Additional people.
additional PP.
I am appearing as amicus for the victim.
Okay, state respondents and Mr. So-and-so, amicus curiae for respondent number 2.
Yes.
It is seen that requisite copies of the paper book has not been prepared by the registry to do the needful. List the matter again on, yes, 27/01/2026. Yes.
Somebody has, Your Lordship, given very bad advice to this junior lawyer. He'll get into real trouble.
Anyway, leave that to that first point.
Yes.
Frankly speaking.
Because
I think
what has
doesn't
happened,
have
the
to
whole
be-
ground in this writ appeal was that I was not allowed to be cross-examined. When this order was produced before this honorable court, then now thereafter this affidavit has come. It's very unfortunate. He will get into real trouble for this.
No, no, we are not impressed by the
Mm.
submission.
That's why.
Doesn't hold water.
But yeah, somebody,
But the merits of the
Mm.
case. Yes, maybe if it's required, we can make some observation regarding that. We'll
it is
see.
unfortunate. He's a young,
Mhm. Yes.
May I, Your Lordship? Lordship, I beg to mention item number 23, Your Lordship. This matter to be listed on 3rd of February, 2026.
Both the parties are agreeable.
Yes, Lordship.
My lord, I am appearing for respondent number 5 and 6.
Okay, so
My-
you want your names to be reflected.
Lordship, I'm for the petitioners here.
Okay, not objected.
Yes, today it has been listed for supplementary hearing. I think there's something wrong because the affidavits have not been filed and it was to be listed for hearing on the interim prayer. Maybe there was a mistake in the order.
Now, let's see this thing. Record.
So on the next date, it may be listed for hearing on the interim prayer.
Okay. Anyways, Ms. Nikita, so and Dangit, okay, learned counsel for the petitioner is present along with Ms. So-and-so, learned government advocate for the state respondents and
RB Yadav.
Mr. So-and-so, learned counsel for RBI/respondent number
5 and 6.
5 and 6. Okay, okay, full stop. It is seen that this matter has been listed in the hearing column, while this court in its previous order dated 05/01/2026 had observed that the matter is to be listed for hearing on interim, a prayer for interim relief. In view of the above, matter to be listed in the admission column and listed on, when do you want it?
3rd of February
On 03/02/2026. Yes.
for hearing on the interim note.
Okay, yes, it's the same, so for hearing of the interim prayer made by the learned counsel for the petitioner.
Obliged.
Yes, Your Lordship.
My lord, I beg to mention item number 7, my lord. My lord, this matter will list after 4 weeks, my lord, since there's no interim order in the case, my lord. So I need to take instruction from the client whether they want to pursue the matter or not. It appears that this may become infractus, but I could not take
Okay.
formal instruction from the client. My lord.
Mr. Yeah, will this thing note your presence? Or you don't know, then you're standing
No, no.
here, I thought, okay.
I've taken
Mr.
consent from the other party.
Okay, Mr. So-and-so, learned counsel for the
Petitioners.
petitioner. You're for the petitioner?
Yes, my lord.
You should stand on this side, okay. Learned counsel has prayed for adjournment of the matter by submitting that he may be given time to get instructions
From the client,
from
the
his
petitioner.
clients. Whether they wish to pursue the said writ petition or not.
Well,
Yes.
List
View of
after
the
4
above?
weeks, my lord.
List the matter after 4
weeks.
weeks. When? We'll fix a date during the what? Last week of, this thing, March.
my lord, let it be,
Last week of March,
my lord.
2026. Yes.
And my lord, further one thing, my lord, at number 22, my lord, I beg to mention this at number 20. My lord, here pleading has not been completed. I'm representing the health department, my lord. Health department I short for instruction, but instruction is not yet received now. It's not forthcoming, my lord. So
Okay.
inadvertently it's been listed as a hearing, my lord, because pleading is not completed, my lord.
Okay, Mr. So-and-so, learned,
Standing
Learned
counsel for
for Health and Family Department submits that though this matter has been listed for hearing, pleadings are not complete and pray that he may be given time to receive instructions whether a counter affidavit is to be filed in the matter.
my lord, after 4 weeks, my lord.
In view of the above, as prayed for, less after 4 weeks during the last week of March 2020.
Deeply obliged.
Yes.
Lordship, may I beg to mention this, one pending writ petition, this, without interim order, this, matter may be fixed for 27th of this month.
Okay. Hmm.
Yeah. January.
Item number 1.
My please. My lord, this matter, many occasion adjournment sought. And today again I sought for adjournment because relating to this matter, DRD order has been under challenge before the appellate court, Calcutta. So this writ petition is against the order passed by the district magistrate to auction the property number 2. Therefore, matter is pending before the appellate court. Main appeal is there. Therefore, I ask for beg for adjournment. At least
Just a withdrawal. If it's something is there against, then you withdraw the thing with the permission.
No, my lord, if sufficient remedy is not granted, then this petition will.
But if sufficient remedy is not granted in the Calcutta Appellate Court for whatever case it is, then you will file, you can't come as this thing, writ petition. It will be against the, you'll be unhappy with the order passed by the Calcutta. Calcutta is what, the appellate, this thing, authority?
That appellate authority, because
Then
my lord
be
here,
against-
two
then you
property.
have to mention the appellate authority in the writ petition also.
My lord here, two property. One property has been already auctioned, and that auction order is under challenge.
So if
And
there's
here
an
against the
appellate,
property too.
This thing, if there's an appellate authority, how can you have come to this court?
My lord here only I challenging the
Huh.
order issued by the district magistrate
District
to auction.
magistrate,
Yes,
huh.
district magistrate.
So challenging that also, it has to go before the appellate authority, not in
No.
a form of a writ petition.
This is the order issued by the district magistrate to auction my property number 2. Therefore, we prepare this.
Must be based on some order.
The,
Must be
this,
maybe the
that is,
tribunal- the
DRD,
tribunal has said-
the order is connected with DRD. Even though
If
the related.
tribunal is there,
Yes.
then the district magistrate is only the executing authority.
Exactly.
Then appeal will lie before the appellate authority.
Even then, my lord,
See, so you withdraw your instant writ petition with a permission to file afresh, because now you're still waiting for the outcome of the appellate authority.
Yes.
Then if the appellate authority passes an order, then in your writ petition, it has to change. The whole
that is,
substance of your writ petition will have to be changed.
my
Cannot-
lord, that is
you
there.
cannot keep it
Yes.
pending just like that.
Even though, my lord, I asked him for last time, last chance, because
No, I don't think this thing, because in your writ petition itself, you are challenging an order passed by the district authority.
district magistrate, yes.
District magistrate, who is passing the order based on a judgment
Yes.
passed by the tribunal. So it cannot go in bits and pieces. The tribunal's order has to be a challenge first. So it has go to the appellate authority
Yes.
anyways. So your writ petition, you want me to dismiss your writ petition or you want to withdraw?
Withdrawn with the leave at the
Okay.
file press.
Heard Mr. So-and-so, learned counsel for the petitioner, who has prayed for the withdrawal of the instant writ petition with a permission to file afresh if so advised. On hearing the submission made by the learned counsel for the petitioner, the instant writ petition is dismissed on withdrawal with a permission to file afresh if so advised.
All right.
Yes.
Item number 2.
Lordship, this matter may be adjourned because as per the last court order, this cost settle was to be amended, but
Okay.
I could not contact my client
The learned
after 3
counsel
weeks.
for the petitioner has prayed for adjournment of the matter since he has not, since he need further time to take steps in terms of this court's order dated 21/11/2025. Accordingly, list after 3 weeks.
3 weeks.
You want a date?
Yes, 3
3 weeks on?
The particular date is not equal.
Okay, after 3 weeks.
Okay.
Item number 3.
Yes.
My lord, I have a limited prayer before this lordship. Despite my lord, here my protected case is, my lord, all my grievances has been, my lord, submitted before the commanding officer 340 Field Regiment Army, which is, my lord, this representation is pending before the concerned authority. Therefore, my lord, I am not in this stage to, my lord, argue the matter on merit. Since, my lord, I have ventilated my representation, and that representation cannot be keep pending for, my lord, this long time. Therefore, I have my limited prayer before this honorable court is to dispose of the representation, which is, my lord, will appear in page number 72 to 75. In fact, the matter is pertaining to the land matter, and the land matter that this pertaining to the dispute of the land matter has already settled. That is not in the issue now, but I have shown a certain document to show this honorable court that the land belonged to me. My lord, may kindly come to page number 72. Representation praying for the assessment of the army occupied area at the Guillermo and release the compensation to the landowners. This,
Okay, this is 18/03/2025. So this has not been considered.
yes, this has not been considered.
It's limited only that your representation should be disposed.
Yeah, dispose, so that this time be kindly framed so that they can dispose of within this.
So in the last court date, the respondents were also the same,
Yes,
present. Okay.
in the last occasion, this has come up for the second time. On the last occasion, they were also.
They were present, that means notice was already issued, isn't it?
Yeah.
So we can dispose of?
My lord, as per instruction by DHI, my lord, I am appearing on behalf of respondent number 1, 2, 3, 4, and 5, my lord.
Okay. His
as per
scope is
instruction
very
to-
limited.
Yeah.
That his represented dated something 25 should be considered.
18/3/25, yes.
Yes, my lord, but as per instruction by the DHI, my lord, we have made communication to the department, but still no instruction has been received, my lord.
So let you dispose of the thing.
So more time may be given to take instruction from the
So
department.
you're appearing on behalf of?
M. Kato, my lord, DHI.
Okay. So anyways, so Mr. This thing, M. Kato had prayed for time to get necessary instructions.
Yes.
Okay, so we'll listen a short date
Yes.
when he's present.
After a week, my lord.
Okay. Heard Mr.
Timothy.
So and so, learned counsel for the petition, along with Mr.
And Sora.
M. Soran, appearing on behalf of Mr. M. Kato, learned DSGI, learned counsel for respondents number 2, 3.
1, 2, 3, 4, and 5.
Okay, 1, 2, 3, 4, and 5. And Ms. So and so, learned government advocate appearing for respondent number 6. It is submitted that since Mr. M. Kato is not able to appear today, the matter may be adjourned. Good stuff. In view of the above, list the matter. Give a date
After 1 week.
after 1 week on. Let's fix a date on.
Yes.
When will he be present, Mr. M. Kato? Is he out of station or something?
No, due to some personal difficulty.
Okay,
he
then
leave the court.
next week,
Next
after
week,
1 week,
After 1 week.
on,
And
yes. Then January, when do you want it? Or February, on 3rd,
3rd February.
okay, 03/02/2026.
Oblige.
Deeply.
Item number 4.
Lordship, as per the last court order, this government, this
Instructions.
GSCI was.
Again, he's absent. So what is this matter? Instructions.
Yes,
So
instructions.
we'll fix this in short date. Okay, Syntax, what are the instructions? That means the matter has been partly heard and he just needs instructions. Okay. Mr. So-and-so, learned counsel for the petitioner is present along with Mr. So-and-so. Same order, okay, appearing on behalf of Mr. M. Kato, learned deputy so-and-so, for respondents number
4.
4 and Miss so-and-so, learned government
1, 2, 3.
advocate for respondents number
1, 2, 3, Your Lordship.
1, 2, and 3. Full stop. It is submitted that since the deputy so-and-so is not able to appear, the matter may be adjourned. In view of the above, again, same order, list, when? During the first week of February 2026, yes.
Oblige, Lordship. Item number 5.
Deeply.
Lordship, this case is with regard to Lordship, security, Lordship, protection. Can you see, this is Lordship, petitioners, social activists. And there is a movement, public movement, for segregation of this fake APST certificate holder and genuine APST. In this connection, the organization has
No,
lost
so
many
I think
complaints.
the IA,
Yes.
the IA, so,
No IA, Lordship.
no, there's an IA 318.
I think it is
This is motion, madam.
motion, this is.
Writ petition 13, my lord.
1 3.
Wrong this thing, yes.
Yes.
Okay, yes.
In the movement, public movement, Lordship, they have filed various complaints on the basis of in retaliation. This kindly see page number 20. They have made a press conference saying that they are going to fight against leading this organization and fight against such practices. And in this connection, already they have one writ petition is also pending here before this honorable court for direction in terms of the FX court decision. So kindly see page number 28, Annex 2. This is the FIR.
Well, similar, this thing is pending?
Yes. Not
Where-
similar. This is for police protection, security protection to this executive member of Arunachal Pradesh Tribal Forum. And this writ petition, pending writ petition is with regard to Lordship, honorable court direction for appropriate direction for the segregation of this APST and fake APST. There are so many fake APST holders. This is the issue.
Okay, so the other writ petition
Yes,
is
connected-
concerning fake APST.
Yes, fake APST. They are
Okay.
leading the fake APST.
So, but the instant writ petition
This
is
is-
for security,
yes.
protection,
Yes, they
Under
want
what?
protection.
under what?
Under Lordship, there is a witness protection fund policies there.
Okay, where's the policy? Let's see.
I have just one copy.
So that should also be a part of this thing,
No, that is
with
just-
petition, if you want protection
just
under
protection.
that.
Lordship, my point is on this application. And it's my petition, my request, my prayer is not entertained, so I file this page number 37, Annex 4. This is the only issue here.
Okay, so
This
you
is
want
security-
this to
yes,
be
SP
disclosed?
security. Yes, I have written application to the SP security
Uh,
saying that we may be granted this protection
no.
because they have even fire upon us to whom complaint has been lodged. They are chasing us.
So what is the response?
No response, even that is why this petitioner is
So,
come before.
so we can dispose of the writ petition with an order to consider
The, yes,
yes.
29/10/2000.
whether this thing representation has
Yes.
to be acted
Yes.
upon or not.
Yes,
I think
expedited.
it is
Yes.
disposal.
That
Okay,
disposal.
because you are praying for something, but nothing is there under what
That is
rules,
annexed here.
under what is the
In the
existing
time bound.
law. Okay. Anyways, heard Mr. So-and-so, learned counsel for the petitioner who has filed the instant with petition.
My contention is only page number 37, Annex 4.
Mm.
Yes,
Uh,
My application
uh,
is pending.
with petition, but praying that an appropriate action may be taken by the respondents by considering the
Representation of
representation filed by the
petition.
petitioners before the superintendent of police, within bracket security,
Yes.
PHQ, Itanagar / respondent number.
This is the respondent, this is the respondent, for item. Respondent 4.
Okay, respondent for. Full stop. Then the learned counsel submits that the petitioners being the members of Arunachal Pradesh Scheduled Tribe Forum has been taking active steps against the fake APST. Is it?
Yes.
Certificate holders for which they have been attacked with no, for which they have been
FIR is already
threatened.
yes,
Okay,
FIR
threatened
is already registered.
and attacked by the goons sent by the fake APST holders. Full stop. The learned counsel submits that because of the threat to the life of the petitioners, they had also filed an FIR against the miscreants. However, miscreants and therefore need protection. Need protection and have therefore made the representation before the respondent number
Yes, 4.
4. Good stuff. However, till date, no steps have been taken by respondent number 4 and hence the instant writ petition. Full stop. Ms. So-and-so, learned counsel for the government advocate, is it? Learned government advocate for the state respondent submits that since the prayer made by the petitioners is limited to is limited to a request that the representation made by the petitioners to respondent number 4 should be considered as at an early date. She has no objection to the prayer made by the petitioners. Full stop. On consideration of the submissions made by the learned counsels for both the parties, this court find it appropriate to dispose of the instant writ petition at the motion stage, considering the fact that the writ petition is limited to only a prayer for the respondent number 4 to consider the request made by the respondents dated 29/10/2024 for 2025 for providing immediate police protection / security. Accordingly, the instant writ petition stands disposed of with a direction to respondent number 5 to consider the request made by the petitioners dated 29/10/2025 and dispose of the same as found appropriate within a period of 3 weeks from the date of receiving a certified true copy of the instant order. Yes. WPC number so and so stands disposed of as above.
Item number 6.
May please, Lodge.
Yes.
Lord, here the challenge is made to a initiation of a departmental proceeding, Lord, which lacks jurisdiction. Now, Lord, the petitioner was appointed as a stenographer. By page 14 is the appointment order.
Why do they lack jurisdiction?
My Lord, the service condition of this petitioner is governed by a statutory rules framed under Article 309, my Lord. Now, it is Arunachal Pradesh State District Court Service Rules 2013. And it is very apparent.
Where are the rules?
Page 14 is my appointment order.
Where are the rules?
My rules, I have a copy of the rules.
Enclose those rules
My
in
Lord.
your writ petition.
Yes.
Okay.
If your Lordship will kindly see, it is apparent from my appointment order that I am governed by this rule.
But
Page 15.
see, disciplinary proceedings, whether they are going to be excluded, action taken under disciplinary proceedings, we have to look at the rules. Rules have to be made a part of the writ petition.
So the rules which has been invoked is Central Civil Service Rules,
Ah.
Rule 14. It is apparent from the so cause.
So so you have to make the rules, that is the district court services rules, whatever, Arunachal, a part of your writ petition so that we can have a proper look at which portion of the rules exclude the staff of the district court from being considered under the central service rules.
If your Lordship will kindly turn to page 14, my Lord, my appointment order. No, that makes it very explicit.
No, even then, the appointment order, disciplinary proceedings,
This rule contains a different code of disciplinary proceeding.
that's why
Right.
the rules need to be made a part of the instant writ petition. That has to be examined and it has to be there.
Yes.
You
But
have not
may I
made-
just
so-
point out, my Lord, I have a copy of that.
Affidavit incorporating the rules which you are going to rely upon.
My Lord. But the difficulty is under the show cause, my Lord, day after tomorrow is the date, and there is a caution made under Rule 20. It may
This thing, it can be quashed anytime, whatever, just a show cause.
No, my Lord,
Short date.
under Rule 20 of the CCS rules, which has been made applicable, though not applicable. Under that, my Lord, if I don't submit my reply on 20 day after tomorrow, they will proceed ex parte. Well, that's my difficulty.
Then let them proceed. If we finally discover, we find that this thing, the authorities, they have not, they have based their order on this thing under the CCS rules, which is not applicable, nothing will happen to him. It's okay.
My Lord.
We'll fix a short date.
My Lord,
Because we want to have the rules available here.
Okay.
And then you also mentioned
my Lord, apart from
portion of the rules okay, is actually applicable to the applicant.
My lord,
Which you have mentioned.
apart from this, my lord, there is one more challenge to this so cause is, my lord, there is on a similar set of allegation, there is a criminal case pending. And it's a settled position of law, my lord. Though, my lord, it can parallelly run. But if the allegations are same, it is always advisable to keep the departmental proceeding in abeyance. Now, because the allegations apparently from the so-called notice are the same what is made before the police, my lord.
You have the rules. First, we'll see whether the authority who has taken steps, they have relied on the correct distinct rules or not. That is the first thing we have to look into, isn't it? Thereafter. So that's why I've just glanced through your distinct petition, but the rules are not available. I cannot really see whether your writ petition is whether notice should be issued or not, because the rules are not available. Now you're coming.
I understand. My lord, at this stage, my lord, as it is a motion stage, my lord, as it is a motion state, if I may allow to keep the rules just for a perusal, my lord, because your lordship will finally have to decide the issue on merits, my lord. I'm sure that.
So the rules have to be, so you just file an additional affidavit incorporating the rules. By the next date, we'll fix a short date.
My lord.
Okay, bring on record the rules you're going to this thing rely upon. It should be available here.
Day after tomorrow.
Yes, a short date, any date you want.
Can it be day after tomorrow, my lord?
Next week. Okay.
But the only difficulty is the last date is day after tomorrow. Well, therefore, what I was proposing, my lord.
Have it day after tomorrow.
My lord.
Okay. Heard Mr. So-and-so, learned counsel for the petitioner, who has prayed that he may be allowed to file an additional affidavit, incorporate to bring on record the what district.
The Arunachal Pradesh. The Arunachal Pradesh District Court Service Rules 2013.
2013 on record. Since the said rules is necessary for the proper consideration of this instant writ petition. Okay. Praise aloud. Let's day after tomorrow's date. What's day after tomorrow? What's the date?
22nd.
On 22nd.
20.
Yes, 01/2026.
Helpful, my lord.
Item number 8.
May I please also? My lord,
Yes.
pleadings are over, my lord. It is ready for hearing. My lord, we are praying for disposal of this case today, my lord. Well, there is a short matter, my lord.
We'll fix a short date. Okay. Next week, when do you want it?
My lord, otherwise I consider pleadings of the petitioner.
You consider, okay, so you're not, you're the
Complainant.
respondent number?
4.
4.
Yes.
And what is the writ petition about?
Writ petition, my lord, I am challenging the,
Eviction. This is eviction matter.
let it be on next week.
Eviction?
Yes, ma'am.
So you're the private, this thing?
Yes.
Complainant.
Complaining.
Lordship, he's considering will not do, Lordship, because he have illegally, Lordship, constructed.
Okay, no,
in between the.
okay, so this is an eviction against, so you have passed an order to evict?
No.
No.
Is it?
No, ma'am.
He is the complainant, Lordship.
Okay,
My lord.
complainant regarding the eviction. So now you want to this thing, evict or what?
No, encroachment, he have complained.
Okay, so then it matters to be heard, because I think the government has something else to say.
Yes,
Lordship.
That
The
will be next
private,
week.
this thing, it's between her.
Next week.
So, you admission hearing, we'll fix a short date.
My lord.
Lordship, let it be on 12th of February, if they are ready.
Well, please. My lord. No, no, sir.
Mr. So-and-so, learned counsel for the petitioner is present, along with Mr. So-and-so, learned government advocate for the state respondents, and Mr. So-and-so for the private respondent. Okay, then on the submissions made by the learned counsels, list the matter on
12, ma'am.
12/02/2026 for admission hearing. Full stop. Then interim order passed earlier shall continue till the next date of this.
Obliged.
Item number 9.
May please, my lord, this matter, there was some difference between the affidavit filed by the department and the government.
Huh.
So now I'm told that
Conflict of interest.
yes, original document is at Pasigat. So I have directed him to call the document, original documents. So this matter may be taken up next week.
Okay. Both of you are the state.
Yes.
Okay. So you should.
There is
together.
two appointment order, conflicting orders.
Okay.
My lord, then service book may be called for, if that is so.
Why? Because what? It's regarding the what? Date of
Pension.
birth or what?
Pension.
Pension.
Yes.
You reproduce the service book if it's required. What records, isn't it?
Whatever this there will.
Mr. So-and-so, learned counsel for the petitioner is present along with Mr. G. Tarak, is it?
Yes.
Learned standing counsel for RWD department and Ms. So-and-so, learned government advocate for the state respondents. And the learned standing counsel submits that since there are some differences in the counter affidavit filed by the state respondent. Have you filed a counter?
Yes.
Counter affidavit filed by the state respondents and the
Rural Work Department.
and the RWD department. He may be given time to produce
My lord.
the necessary records to clarify the same.
My lord, which document, my lord? That may be clarified, sir.
Documents to clarify the same. We'll see. In view of the work. That's the matter. When can you produce the documents
29.
on?
My lord, then for February,
No,
Okay,
but
just the
uh,
it will difficult for me.
or 5 February then.
Fifth.
Yes.
Okay, it is the matter as sought for on 05/02/2026. Yes.
No, please.
My lord, all the affidavit is ready, my lord. That may be also.
So those documents, let them be there and then it can be clarified maybe. Okay. Mhm.
Yes.
Oh, yes.
Item number 10.
My lord, this poor petitioner is a retired government employee as a principal. He was arrested in a criminal case, my lord. But the CBI, who was investigating the matter, has not charge sheeted the petitioner herein, my lord. Then he retired on 31/1/2024. And till now, my lord, for want of the NOC, he could not process the pension paper.
This is pension matter.
Yes, my lord.
So,
They,
counter affidavit filed or not filed?
I have filed, but the other parties have not, Lordship. Lordship, he's alleged
Main
accused in
respondent file case?
PPC paper leakage scam, Lordship, actually.
Okay, anyway,
The
so the
petitioner.
concerned department where he was previously employed, you have to file your counter affidavit. if any.
Just let them.
But this being a pension matter, you
My lord,
have to do it expeditiously. We
my lord,
can't
this
keep it
vigilance department was the main party here. Then they have filed. And others is not required, my lord.
He
And
says,
kindly have this.
can you depend on the counter affidavit filed?
My lord, I have to see whether I have not been furnished, my lord. This, I need to see that whether it can be just covered up or
Okay,
not.
My lord,
okay.
my lord, I have this. The affidavit filed by.
So we'll give them a
This
short
week-
late
next
chance
week, Lord.
to
Yes,
get
ma'am.
instructions whether you're required to file a
No,
counter affidavit or positively by
My
the
lord,
next court date.
my
Pension
lord,
matters,
last, there was an,
disposed of.
there was last order 20.
Uh,
There was a last order which clearly says that if not filed, it is a issue of waiver. Now vigilance department, they says
They say here.
that there has not
given
been charge
chance
sheeted.
To file their counter affidavit.
Correct.
If any, okay? if not already filed, another date. So now we will give a final chance. If
Madam.
not, we will not give you any more chance, okay?
Well, my lord,
But
sort
we
that,
will-
because like
we'll-
the main, my lord, the main, the vigilance department has already filed the
So maybe
affidavit.
they can depend upon this thing, rely upon that, okay? So
Hmm.
heard Mr. E.T. Tara, learned counsel for the
Thank you.
petitioner, along with Mr. So learned standing
Yes.
counsel for which department?
Education Department, my lord.
For Education Department / respondent number?
Respondent number, my lord, the one,
No,
two,
that's
no, one, respondent number 1 and 3, my lord.
1 and 3, full stop. The learned counsel for respondent
file ka.
number 1 and
Two file.
3 submit
file ka.
that
No,
he
one
may
and
be given time to get instructions whether they are required to file a counter affidavit or rely on the counter affidavit already filed by
the respondent number 2.
the respondent number 2. Yes, you're appearing for whom?
I'm for respondent number 4.
CBI.
On behalf of M. Kato, ma'am.
Okay, so are you going to file anything?
Yes, my lord, I am, our affidavit is ready. There is some. minor
Okay. The learned counsel, Mr. So-and-so, appearing on behalf of Mr. M. Kato, learned counsel for respondent number 4, also
11,
submits
la-
that the
11
counter affidavit is
disposal.
ready and will be filing the same positively by the next court date. In view of the above submissions, list the matter.
On
11 closes.
11 Feb.
Okay, on 11/2/2026, wherein final chance is given to the standing counsel and respondent number 4 to file their counter affidavits, if any.
Well, only a small observation, if I'm allowed to request. Endeavors shall be made to dispose of the read petition that day.
Let this thing, the concern this thing, final chance, okay? Then the sitting in this thing will decide whether it can be disposed of. You press for that.
Okay, well, this is final chance.
Yes, I've said final chance.
I'm grateful. Let it be in the admission column itself.
It will be in the admission column.
Item number 11.
Yes.
Your Honor, I am for petitioner.
Yes, so pleadings are complete or what?
No, Your Honor, this is in motion.
No,
What motion?
we have already filed a affidavit of opposition.
So do you want to file your rejoinder affidavit?
No, Your Honor.
What?
Your Honor, petitioner is a registered contractor, Your Honor.
So here, the writ petition, there's a submission made by the standing counsel that the writ petition itself has become infructuous. So what is this thing,
This construction of school building.
which is complete? Oh, no, not yet.
I have no answer, but by this time it must be completed.
Okay, we'll fix another date. You get this thing.
Yes.
Okay, find out. What is the writ, this thing? The writ petition is concerning
Concerning-
construction of a school building.
This is violation of this CPW manual, Your Honor.
Okay.
Allegation is that due to short notice, he could not participate in the tender
Okay,
process.
because you could not.
Yeah.
So do you still want to pursue, supposing now that this thing, construction is going on, is there any interim order staying the, nothing?
No, no interim.
So find out whether you want to pursue the instant writ petition or not. What is the state concerning the construction of the school building? Is
Regarding
it continuing?
regarding this, I have no idea, Your Honor.
First, find out. Okay.
Your Honor, we are concerned about the this notification issued by the authority on 12, which due to which we are lacking participate. Your Honor, it is notification issue on 12th of 2000
Where's the notification page?
page, Your Honor. Page 17, Your Honor.
17.
No, tender notification issued on 12th of March 2025. Yeah. And on 14, there is a holiday, Your Honor. And 15 is a Saturday. So due to this, we cannot participate.
Okay, you could not participate. He is saying that now the work has already started. Is it?
Yes.
Yeah.
And
At this stage, I think it must be completed.
and could have been completed already. So you find out the present situation, because even supposing you want to participate in the tender, but if the works for which you want to participate is already complete, then what will happen? Then with this concerning the writ petition, will there simply be wastage of time? Because what relief then?
Yes, no purpose with that.
Whether your relief which you're praying for is still available or not. See that, and then come again in the next court. If you feel that you are still entitled to certain relief, what is your prayer to be allowed to participate in the tender? That will be a prayer, I think. Okay. Then see, even if you, is it possible to pursue the writ petition if this thing, school building for which this tender is floated is complete or not? Because in the previous court date also, this submission was made that the instant writ petition appears to be now infructuous. So find out. Okay. Then come up with proper instructions. This was filed on, yes, 2025. But you never prayed for a stay, is it?
Yes, Your Honor.
You never prayed for any interim order. So if you did not pray for any interim order and the works have already, this thing started and appears to be as submitted by the Learned Council completed, then see whether you need to still pursue the instant writ petition. Understood? Yes. Heard Mr. So-and-so, Learned Council for the petitioner, along with Mr.
G. Tarak,
G. Tarak, Learned Standing Council for
RWD.
RWD. Full stop. In the Learned Council for RWD submits that the works for which the tender was floated, for which the impugned tender dated 12/03/2025 was floated, appears to be complete, and therefore the instant writ petition has become infructuous. Then Mr. So-and-so, Learned Council for the petitioner, submits that he may be given time to verify the same and get necessary instructions. In view of the above, you list the matter. When will you be able to do? Is the matter on?
After 2 weeks.
Okay, after 2 weeks on, we'll make it 12/02/2026.
All right.
Item number 12.
May I please, Your Lordship? This is regarding suspension, Your Lordship. The petitioner here has been suspended from service
May I, Your Lordship?
on 9/3/2024.
This is
And,
one thing. Whatever the case is here, we have to always look at the previous order. Here it says that additional affidavit
Yes, Lordship.
Lordship,
is allowed. So where's the
prior to
additional
that, prior to that, record was called for.
Huh.
And therearafter,
They want to
learned
file an
senior,
additional affidavit.
yeah.
they wanted to file, but
So
Not
some more
yet
time will be
filed.
needed, Your
Why?
Lordship.
What?
I think we have not received
otherwise
the
the
complete,
issue,
Your Lordship,
What?
instruction.
See, you know your case
Yes,
and
Your
you want to
Lordship.
file an additional
Yes, Your
affidavit to bring on record certain documents or whatever. So why have you not filed?
So, sir, Your Lordship needs some more time, Your Lordship.
Lordship, the issue here in the present case is that whether the suspension review was in time or not. And regard to that, I have filed an RTI. That documents reveals that the suspension review committee was passed an order, backdated order passed. So which I can show prima facie on the face of record, I
But
will
we
show.
will give them a chance because
Yes, Your
this
Lordship.
court in its previous order had allowed that additional affidavit be filed because they have received additional instructions.
No,
It was
that,
Mr. S. Tapin who had appeared.
Yes, Your
Yes,
Lordship.
yes.
He's appearing to
He
this
is
matter,
not
Your
here
Lordship.
today
Yes, Your Lordship.
to explain.
he was here. Lordship.
So we'll give them a short date,
Yes, Your
find out what are the instructions. If he was present, we could have asked him what was the additional instructions received. But since he is absent, we'll,
All right, Lordship, prior to this order, there is a direction to produce the case record, Your Lordship. The documents which I have relied upon, received through the RTI, that record was also called for.
okay.
So
So
whether that
the
record,
government advocate will have to take steps, isn't it? Or it is the standing council?
that record has already been received by
Okay,
them.
received. Okay, fine.
Oh, there was,
That they will produce before the.
yes,
when the
yes.
matter is-
Next date, Your Lordship.
Yes, heard Mr.
Otherwise, the petitioner is under suspension almost 2 years.
We'll fix a short.
And no
Yes.
departmental proceeding, nothing.
Heard Mr.
AK
Singh,
Your
is
Lordship.
it? Learned counsel for the petitioner. Full stop. Also heard Miss so-and-so, learned government advocate, who has prayed for time to file
Additional.
the additional affidavit in terms of this court's order dated 22/12/2025. In view of the above, 2025 and prayed for a short date. Okay. In view of the above, list the matter on
Lordship, let it be in the first week of February, Lordship.
okay, in view of the above, as prayed for a list on.
Either next week or first week of February, Lordship. I don't,
So- Yes, when will you be able to?
next week if possible, then
Next week, Your Lordship.
Okay, first week of February. Okay, so that we don't keep adjourning, file your affidavit. In view of the list the matter on 5th February. Okay, 05/02/2025. Yes, the standing council, what do you have to do?
Malad, I'll not be filing because this relates to the
is
general administration,
Mr. So-and-so, learning standing council for, which department is it for?
education department.
For education, the department submits that they will not be filing any counter affidavit and will rely on the affidavit filed by the state respondents.
Lordship,
In view of the above, okay, list on. Yes.
on the next date, ensure that the additional affidavit can be filed, Your Lordship. Several
We can
adjournments.
just this thing, list on so-and-so for the state respondents to file their additional affidavit positively.
Yes, Your Lordship.
Item number 13.
Yes.
Wait, please, Your Lordship. Your Lordship, may kindly have the IM. Page 13. This is a notification issued by the Secretary Public Service Commission. This is pertaining to my lateral entry. If Your Lordship kindly have the next page. These are the list of candidates who have been declared eligible by a committee. Page 13 and 14.
So what is, so this is apply for implement of
Yes, yes.
applicants?
Yes, this order is
As
under
from
challenge.
number 7
This
to
order at
18.
page 13 is under challenge, my lord. The applicants are those whose names are here at page number 14. So I'm a necessary party. Similar matter we have already been implemented, my lord.
I think, let them be impeded.
Lordship,
Yes.
What is the-
I am appearing on behalf of the council Tagum Jamo, T Jamo. So he instructed me that there is no objection.
7 to 18, my lord. Respondent number 7 to 18.
Okay. So you are the petitioner in the writ petition, is it?
No, they are the petitioner. I'm
But-
I'm the applicant.
Okay, applicant and the respondent. No, nothing. You're
Not-
not
not
being
yet,
a
yes.
party. Okay.
We are the
Heard-
persons
yes,
whose
yes,
name
yes,
appear
you
at
have-
page
You have not been made a party, huh? Heard Mr. So-and-so, learned counsel for the applicant who prayed that they may be allowed, the applicants, okay, may be allowed to be impleaded in the connected writ petition number 551 within brackets AP 2025. Since the applicants, the interests of the applicants are also affected by the connected writ petition
Right.
number, what was it?
551
Yes, 551
2025.
slash 2025. Full stop. Then, Mr. So-and-so, learned counsel for the opposite party slash writ petitioners in the connected writ petition number 551 slash 2025 is present and submits that he has no objection to the implement of the instant applicants. Full stop. Yes, this thing, last court date, Mrs. Education Department was also present.
Yes, ma'am.
No objection. Okay, Mr. T. Tagum, learned standing counsel for the Education Department, also submits that he has no objection to the instant IU. In view of the above submissions, the instant application, interlocutory application stands allowed, and the applicants are to be impleaded as respondents number
7 to 18.
7 to 18 in the connected writ petition number so and so on. Full stop. Accordingly, IA number 318/2025 stands allowed and disposed of. Now, in the main writ petition, on the disposal of IA number 318 of 2025, allowing the implement of the applicants as respondent number 7 to
18.
18, the learned counsel for the petitioner is to take necessary steps by making a correction to the cost title of the petition, and thereafter copies of the requisite copies of the writ petition to be duly furnished to the newly impeded respondents by the next court date. This the matter, yes,
3 weeks.
after
3
3 weeks.
In the meantime, we'll file it.
Whatever.
Item number 14.
May I please, Lordship? Lordship, the issue involved in this writ petition is that, my lord, the land where the proposed here building is being constructed, my lord, it is the private land of the petitioner. It was never acquired, and the document which I have annexed in my writ petition is the official document, my lord, that will show that the exact position of the land. In fact, my lord, the administration of that area is also in admission that the land was never acquired. So they are proposing for this acquisition of land freshly in the
So what, huh? So your
Now-
acquisition of land, huh?
yes, my lord. My lord, may kindly take up my writ petition, my lord. I have filed one additional affidavit,
Wait,
my lord.
so in the last, let's see, what is the stage here? You had prayed to file affidavit in reply.
I have already
The
filed and I have supplied the copy also in
Okay.
this.
So pleadings are complete.
Yes, my lord. My
Next
lord,
date for admission.
both of us, my lord,
Ah.
are proposing for disposal of the matter, my lord.
Yes, it can be.
Next week, next week. Okay, Mr. So-and-so, learned counsel for the, yeah, petitioner is present along with Ms. So-and-so, learned government advocate for the state respondents. It is seen that pleadings are complete and therefore this matter is to be listed for admission hearing
On 28, my lord.
on 28.
Yes, my lord.
28/01/2026.
Yes, much obliged.
Obliged.
Item number 15. 15 to 17.
My lord, in item number 15, in respect of respondent number 5 and 6, the AD has been received. And in respect of 4, 7, and 8 are still awaited. And the rest, I think they are making their appearance today,
Okay, so we'll wait for something.
my lord.
Mr. J.
Siri.
Sarinki, learned counsel for the petitioner is present along with Ms. P. Sangeeta, learned government advocate for the state respondents number 1, 2, and 3. And Mr.
Jayasring,
Okay, so and so,
I am for respondent number 11 to 20.
learned counsel appearing on behalf of respondents number 11 to 20. Full stop. We may await for return of AD card upon respondents
4, 7, and 8.
number 4, 7, and 8. Since AD card in respect of respondent number 5
And 6.
and 6 have been received back. Full stop. In view of the above, list the matter after 3 weeks.
3 weeks.
Awaiting for return of AD card from the said respondents, number so and so. Okay, yes.
In item number 16, my lord, the AD card has been received in respect of respondent number 4, 5, and 6. And 7, 8, and 9 are still awaited.
Okay, so then you are for respondents number
10 to 15.
10 to 15. Okay, same order 10 to 15. Then we may await for a
Okay.
return of AD card from respondents number 7, 8, and 9.
And
Is it? 7, 8, and 9. Yes. So wait, for private respondents, you are for which respondents?
10 to 15.
10 to 15. So 4, 5, and 6 is who? They are represented? No.
No, AD card has been received.
Okay, yes. Okay, then we can say that it is seen that AD card upon respondents number 5, 4, 5, and 6 has been received. Okay, same order of the only number is there. Yes.
In case of serial item number 17, my lord, they are representing all the private respondents.
From 4 to 8.
4 to 8 we have mentioned. Four to
Item number 17, my lord.
17, 4 to 8.
4 to 8.
4 to 8. The other one was in reference to item number 16.
Previously, we have passed for item 16. Now for item 17,
Altogether,
same
there-
order,
three-
only the respondents will be.
Three items, my lord. 15, 16, and 17.
Oh, okay. So 15 we have passed, 16 the previous one, so 17.
17. It's appearing for all the respondents, my lord.
So where's the file for item number 17? Three, 338. That's it. Yes. So here, so and so is for the petition is present along with Mr. So and so, learned counsel representing all the respondents.
Private
Okay,
respondents.
and private respondents and Ms. So and so, learned government advocate for the state respondents. The learned counsel for the respondents have prayed for time to file their counter affidavits. Okay, in view of the above, so it's
Grateful.
same.
Grateful.
Item number 18.
But 18, 19 and 20, the matter.
All of them are fixed. 18, 19, 20. What about 21? No.
21 is not.
Okay.
But it relates to a tender process, my lord. Now, my lord, after the affidavit has been filed by the government, one thing is very clear, my lord, they have admitted the claim of the writ petitioner, my lord. Now, what is required is that the tender documents are to be re-evaluated by the tendering authority. Now, as there is an order, my lord, interim order, they could not do so. Though, my lord, they have initiated a process for re-evaluation. In fact, my lord, what I'm proposing is, if your lordship can dispose directing the tendering authority to re-evaluate the bid documents of all the bidders.
Oh, so notice is complete.
Yes, service is
Through
completed.
DASI?
Yes, service is completed. We have filed our affidavits also.
Okay, so we'll make that observation first, isn't it?
Mal.
Mr. So-and-so, learned counsel for the petitioner is present and submits that service of notice upon the private
respondents
complete by filing the affidavit to that effect, wherein in the affidavit it is seen that, what is the affidavit?
Affidavit dated yesterday's, my lord.
Wait. In the affidavit,
6 and 7 are
wait, dated 05/01/20. Is it?
no, my lord, it is 19 January 2026.
Dated, wait, let me just see.
19/01/2026.
19/01
2026.
2026, that notice was served upon the,
Respond number 6, 7.
wait, let me see,
Hello,
where
yes.
is that affidavit?
847.
This is affidavit in opposition. Where's the affidavit of? Okay, here.
Page 540 is the acknowledgement.
Yes. Affidavit in regards to, when it shows that affidavit to, so your respondents start from 8, is it?
My lord, in
Respondent number 8. To respondent number 8 was served. No date is given.
page 540, my lord. Respond number 6, that is 16/1/2026 received.
Yes, it's 6, 7 and 8, is it? Or only 6?
6 is 540. 540.
Wait, the
4 is
citation is
respond
not
number
done
7.
properly, so you have to go back, where the this thing notice to respondents number 6. 540. Was received on 16/01/2026, and notice upon respondent number 7 was received on which date? Where is it?
It is 10/1/2027, 2026.
Okay, 10/01/2026, comma, respondent number 8 was on.
11.
Okay, 11/01/2026. Anyone else?
No.
Okay.
Yeah.
Okay, so instead of comma and, in view of the above, this court finds that notice upon the private respondents number 678 was deemed to be complete. None appeared for the private respondents number 6, 7, and 8. Then what?
Then, my lord,
Do you have filed a counter?
yeah, no, I have filed my affidavit, my lord. We want immediate disposal of this writ petition, my lord. Actually, MG Narega, we have a target of 100 days, my lord. We have already lost 20 days now. Now we have left only 80 days, my lord, for execution of work, my lord. Because due to the interim order, we cannot continue with
The counter affidavit has been filed by the state respondent.
Yes, my lord.
And we have filed our reply to that, my lord.
For which rejoinder affidavit has also been filed in view of the above. Pleadings is complete. Matter be listed for admission hearing.
Well, this
Give a date
matter-
next week.
This matter may be disposed of, my lord. There is
next
some
week.
urgency, my lord. Due to the.
In fact, my lord,
Next week,
my lord,
meeting
in fact,
today, on Tuesday. Okay, list the matter on 27 01.
Can it be 29, my lord?
Okay, on 29 01 2026, wherein an attempt will be made to dispose of the instant writ petition, since urgency
Yes.
in the matter has been expressed by the learned counsel.
Item number 19,
17, 18, 19, yes. 19, 479.
19 similar.
Similar, my lord, here, private respondent are served.
Okay, so pleadings complete?
Yes.
So it's similar matters. So actually, all the matters can be disposed of together.
Yes, all the matters.
Wait,
In fact, my lord,
come back with that. It
In
is
fact-
also seen that the writ, no, it is also submitted that this matter may be listed along with writ petition number 479/2025. Then a writ petition number 480, is it? /2025. And only those two.
and 472, all three together.
Yes.
472,
So in
479.
472, I'm passing the order.
Yes, 479 and 480.
Since the matters are analogous matters. Okay, full stop.
29.
Now, then in item number 19, 479, this thing, notice complete. Is it
Yes.
Service, it is seen that a service of notice is complete and the pleadings are also complete. Matter may be listed along with 472/2025. Yes. Then 20,
20,
notice complete?
20, I mean, 20 also notice complete. So,
Okay.
480.
Again, same order, along with 472/20. Yes. Then an attempt can be made, okay, in the next court date. Yes.
29, all 29.
on 29, no, ma'am. Leave on
Pardon?
29.
Listed
All on
29. So in the first, this thing I've said to be listed along with the others. Okay,
Well,
so when we just say along with the first one,
so all will come together.
on the same date.
Yes. Grateful, my lord.
Item number 21.
Steps not taken
May I
by
please
the
your,
petitioner.
may I please your worship? In regarding the private respondent number 6, we need to take fresh step.
Okay, steps have not been taken only. What fresh steps? You have not taken.
Yes.
steps As per her.
On as on the
Okay,
9th,
Mr. So-and-so, learned counsel for the petitioner, has prayed for time to take steps for issuance of notice upon the private respondent number 6.
Yes, 6.
Praise the Lord. This is the matter again after 3 weeks.
and your worship, there is an interim also. Sir.
Okay, the presence of, then after 3 weeks, meanwhile, is there? Where is it? Where is the interim?
In the order, it was mentioned in 7
What?
of the last order of
Where's the-
9/1/26
The interim order.
shall be stated the next date. That Question, column 7.
Okay, consider this
Yes.
okay, interim order passed earlier shall continue till the next date of listing, full stop. Then the presence of Ms. So-and-so, learned government advocate, and Mr. So-and-so, standing counsel for respondent number 24 is noted.
May I, Your Lordship, they have not served extra copy to us, Your Lordship.
Will
You
that-
please serve, no need to my written order, just the serve, okay.
Much obliged.
Obliged, Your Lordship.